So a viewer sent this story in this week. Apparently, Richard Liebowitz, everyone's favorite copyright troll, which, if you remember all of Leibowitz's shenanigans and all of his cases, Glenn Craig was the no, go after guy from, I think it was last summer in 2020. There was this hearing where Liebowitz filed the case, but Glenn Craig tried to tell the court that he shouldn't have filed the case because no, go after does not mean go after in a lawsuit. It means something else. In fact, I think we did a reenactment of the court hearing because the Judge Stacy Yandel, I think her name was, had ordered Craig to testify under oath. And there was this whole exchange.
Mr. Craig.
Yes?
In reference to Pot Matters, there is a web address. And then afterward, it says, no, go after. You see that?
Yes.
Is no, go after. Are those your notes?
That is my notes.
What does that mean?
That means to him, and we spoke on the telephone to him, and I went through these verbally with him, one by one, to review each one, okay? For him to...
Mr. Craig.
Yes?
Mr. Craig. I don't need the context. I need...
Well...
Hold on. I need you to answer my question. What do your notations, no, go after? What does that mean? What were you communicating?
I was saying to him, and I called him up afterwards, immediately, that is what is at stake here, okay?
Mr. Craig, I didn't hear your answer. What does no, go after mean?
That means a partial go after, but to be reviewed.
Okay, what does go after mean?
Go after means when he was sending me these lists, okay? He was sending things that were legitimate, that should never have been sent to me, and a lot of these other cases.
Mr. Craig, you're not answering my question. I'm sorry, you're not answering my question. What does no, go after refer to as it relates to the Pot Matters case?
In an instance where I'd say no or yes, I said no, and if you look at the other ones where I said bluntly yes, that was a definite yes.
Now, what are you saying no to? I'm trying to get to what no refers to.
No means as follows. There was problems with what he sent to me, Your Honor, in 2 or 3 different cases. So if it was put as no, okay, it did not. If you look at your other documents there, it says yes, okay? So it was a train wreck. And I'm not sure if the judge has actually ruled in that case yet. I will have to check that out. But now what we have is Liebowitz suing Glenn Craig. And in order to find out what he's suing his client for, we're going to have to read through this. Thing is, lawyers are not really supposed to sue their clients. Now, you have the right to sue a client. Of course, the court system is the preferred way to resolve disputes that can't be resolved civilly, otherwise. So you turn to the courts, and there's nothing directly wrong with that. But indirectly, it's usually not a good idea to file a suit against a client because, one, you're inviting scrutiny to your own actions. And as we know, Liebowitz has not always acted and has often not acted with the proper professional conduct and honesty and candor to the court. Shenanigans, I've been calling them. And so Liebowitz is now going to open himself to more scrutiny when he's already not doing really well in the scrutiny department. Second, it opens the lawyer to some kind of a bar complaint. Maybe the defendant doesn't file a bar complaint, but it also significantly increases the chances that a client is going to institute some kind of a bar complaint. My lawyer was a bad lawyer who violated his disciplinary duties or his professional duties and deserves discipline because he filed a suit against me and it was less than meritorious, is usually how that goes. Now, I don't know how entirely meritorious this is because we're only going to see the Liebowitz side of this right now, as this has just been filed. I think I received it on September 1st from our viewer. Thank you for sending that in. And We don't know. Maybe this is a totally meritorious lawsuit. This was where I made a video asking if maybe Liebowitz was the wronged party, and you can decide for yourself. Let's take a look. LLF is a professional limited liability company under the laws of the state of New York, principal place of business in New York, specializes in enforcing copyright works on behalf of clients. Craig is an individual domiciled in New York, a photographer who takes photographs of musicians in the late 1960s or 1970s. The court has jurisdiction according to the Declaratory Judgment Act and Copyright Act, so we already know that Liebowitz is going to be asking for a declaratory judgment, which is a federal law, and copyright, which is a federal law. That gets him into federal court instead of having to deal with the state court system. Factual background. Craig purports to be the author and copyright claimant of a photograph of jazz musician Miles Davis, which was taken in 1971. On November 20th, 2014, Craig purported to register a number of photographs of Miles Davis, including the photograph at issue, with the Copyright Office as an unpublished collection under registration number 2067, with the content title Miles Davis Photos, all JPEGs 1970 to 71. They're going to refer to it as the 067 registration. However, the Miles Davis photograph was published prior to November 20th, 2014. On or about February 18th, 2014, prior to the effective date of the registration, Craig entered into a commercial license agreement with Sony Music Entertainment concerning the Miles Davis photograph. Craig therefore published the Miles Davis photograph at least 9 months before he registered the photograph as unpublished. On September 11, 2018, Craig filed a one-count petition against Pop Matters in the United States District Court for the Southern District of Illinois, which was subsequently refiled in the Northern District of Illinois. Now, here's where I think Liebowitz screwed up, because I'm guessing that Craig didn't order Liebowitz to file it in the Southern District of Illinois when it should have been in the Northern District of Illinois. And I think that's going to be on Liebowitz. And so again, Liebowitz is opening himself up to further scrutiny. I guess he's just taking the chance. I guess when you've hit rock bottom, there's no place to go but up. Oh, I hope for Leibowitz's sake that it's only rock bottom and not that there's further digging to go. In the Pop Matters action, Craig alleged that Pop Matters infringed Craig's copyright to the Miles Davis photograph by displaying it online without Craig's authority. Craig's standing to sue Pop Matters was based on the alleged validity of the 067 registration. LLF served as Craig's counsel for the Pop Matters action. Craig never disclosed to LLF that he had licensed the Miles Davis photograph to Sony Music and its sub-licensees, including Pop Matters. Ultimately, LLF learned of the license from Pop Matters counsel and, as a result, promptly dismissed the Pop Matters action on Craig's behalf. So according to Leibowitz's version of the story, Liebowitz did everything correctly, or at least he's omitting things that he may have done incorrectly, like filing it in the wrong venue or district. But now he's saying that he didn't know that Sony Music had a license for the Miles Davis photograph, therefore the copyright was in some way invalid, therefore Craig didn't have the standing to sue or the right to sue yet because it was not a properly registered work. And so therefore the case was dismissed as promptly as possible, which I'm not entirely sure that's what happened. Craig's voluntary dismissal of the Pop Matters action in the Northern District was deemed an adjudication on the merits because it was the second time a voluntary dismissal was filed. Remember there was that quirk where you could voluntarily dismiss it once but not twice. Therefore, Pop Matters was deemed a prevailing party, and the judge awarded $24,040.45 in fees and costs. Judge Guzman also denied a sanctions motion against LLF, so he wasn't further sanctioned. In awarding attorney's fees against Craig, Guzman noted that defendant Pop Matters has presented persuasive evidence and argument that it has substantial defenses to plaintiff's copyright claim that defendant's use was licensed and that plaintiff's photograph was a work made for hire. And that decision is here, and so I just thought we'd read this highlighted section. The circumstances here favor an award of attorney's fees, but then it goes on that plaintiff's motivation in filing this action was to obtain proceeds from a settlement rather than to protect against infringing use of his copyright. And the judge then cites to the Design Basic versus Lexington Homes case, a case that we've covered recently. That's the home floor plan case where Design Basics was trying to claim copyright to generic home floor plans. In recent years, opportunistic holders of copyrights, patents, and other intellectual property have developed unsavory reputations for trolling, bringing strategic infringement claims of dubious merit in the hope of arranging prompt settlements with defendants who would prefer to pay modest or nuisance settlements rather than be tied up in expensive litigation. Plaintiff's dismissal of this case appears to have been an effort to avoid paying fees for the first action or to avoid a decision on the merits. So part of the Liebowitz versus Pop Matters case is going to be whether Liebowitz was motivated to dismiss the case because he had messed up on filing it in the wrong court the first time, or whether it was done on the direction of the client to avoid a decision on the merits or having to pay even more fees. Craig purports to be the author of a B.B. King photograph in 1969. Craig purported to register photographs of B.B. King as an unpublished collection, the 683 registration on March 18, 2014. However, the B.B. King photographs were published prior to March 18, 2014. Craig published the photographs when he submitted them to Changes magazine for publication at some point between 69 and 71, which he doesn't say it, but I'm going to read into that Change magazine actually did publish them. If he just sent them to Change magazine for publication, I don't know how published that is, but sure, we could have that argument. Maybe sending them to any third party is publishing, even if they don't then further publish them in their magazine. On July 7th, 2016, Craig filed a 2-count action against Universal Music Group in the Southern District of New York. Craig v. Universal Music. The complaint alleged 1 count of copyright infringement and 1 count of a violation of 1202B, which I think is copyright management information. Craig alleged UMG had used the B.B. King photographs without Craig's authorization and without providing Craig proper credit. LLF was Craig's counsel. During the pendency of the action, Judge Paul Otkin entered an order on summary judgment finding the B.B. King photographs were published in 1971. Further, Craig admitted under oath at his deposition that the B.B. King photographs were published long before the effective date of the registration. The UMG action was settled after Craig voluntarily entered into a written settlement agreement. Several weeks after executing the settlement agreement, Craig attempted to extricate himself from the agreement by falsely claiming he never signed the document. This sounds familiar. This sounds like a case that I handled a few years ago. However, after a full in-person hearing where Craig testified, Judge Otkin determined that Craig had in fact signed the settlement agreement and Craig had failed to demonstrate that he signed it under duress. Accordingly, the agreement was deemed enforceable and the UMG action was dismissed. October 21st, 2020, Craig filed an action in the Supreme Court of the State of New York against LLF and its founding principal, Richard Liebowitz, alleging, among other things, that LLF and Liebowitz had committed legal malpractice in the Pop Matters and UMG actions. Craig's complaint in the state court action alleges that Craig would have prevailed in the Pop Matters action, but for Leibowitz's professional negligence. Craig also alleges that as a result of Leibowitz's alleged negligence, Craig would have recovered more money at trial than he received under his settlement agreement with UMG. On August 23, 2021, Liebowitz filed verified counterclaims against Craig, sounding in actual fraud and deceit, breach of contract, breach of good faith and fair dealing. Specifically, Liebowitz and LLF allege that Craig defrauded LLF by failing to disclose that he had published the Miles Davis photograph and published the B.B. King photographs prior to registering them as unpublished. So then Liebowitz asks for a declaratory judgment. This is where you ask the court to say something is true or false. So he's going to ask the court, or he has asked the court, to declare that the Miles Davis photograph and the B.B. King photograph copyrights are invalid. Literally, copyright invalidity of the photograph here. And then there's going to be another count down here for copyright invalidity of the B.B. King photograph. And if that is it, yeah, that's it. Liebowitz asks for the registrations to be declared invalid to award attorney's fees and award such other relief. And then he has James Freeman representing the Liebowitz law firm, because Liebowitz can't represent the law firm if there's a conflict of interest. If Liebowitz is the proprietor of the law firm, he can't necessarily represent an LLC. It might vary from state court to state court, but my understanding is that when you are the proprietor of an LLC, you have to get an attorney to represent the LLC separately from representing you. So it sounds to me like Liebowitz is trying to undo the burn from the Glenn Craig representation by getting a court to declare that Glenn Craig's registrations are invalid, and therefore it really was Glenn Craig's fault. And if it is Glenn Craig's fault, then he's going to take that judgment to the New York State Court as evidence of Liebowitz and the Liebowitz firm being innocent of the claims Glenn Craig has made. And then I assume there will be some judgment against Glenn Craig. So last year, the viewer that sent this in had written to me that Glenn Craig lives from settlement to settlement, as do a vast majority of Liebowitz clients. He's not a professional photographer. He was employed by a music promoter and had access to the stage at concerts. He took photographs for himself. In the 70s, he occasionally submitted his photographs to music publications. His registrations are all invalid. His infringed works were all published in the 70s and then registered as unpublished. I'm really not sure why you would do that. If he had just simply registered them as published works, they would probably be valid for any infringements that occurred after the date of registration for statutory damages. So this viewer does not think that Craig is credible, so who knows, maybe Liebowitz really is the victim in this case. I'll keep an eye on it and have updates for you. Let me know what you think in the comments below. And thank you for watching. Special thanks to our top supporters in September: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. So here we are, halfway, well, 2/3 of the way through our ride. That's the bridge from Schengen to Pearl over the Moselle. That's Germany on the other side of the bridge. And that's Kaylee.
That's like Pearl over there, Schengen here.
Hi, Kaylee.
Hi.
And this is Leonard.
Hello.
And we are having a nice ride through the vineyards of the Moselle in southeastern Luxembourg. Last year, the viewer who sent this in had writ to me